new immigration rules for green card sponsorship of families, and marriage to a U.S. citizen or green card holder. As the landscape of U.S. immigration evolves, 2025 is set to bring significant changes to the marriage-based green card process. With the potential return of Donald Trump to office, stricter immigration policies are expected, leading to longer wait times, increased financial requirements, and a more detailed vetting process for couples seeking to reunite. If you are interested in this, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell on upcoming video. The landscape of U.S. immigration is set to shift again in 2025, with significant updates to the process for obtaining marriage-based green cards. As Donald Trump makes a potential return to office, the expectation is that immigration rules will become even stricter, mirroring the policies he implemented during his first term. These updates could bring about longer wait times, stricter financial requirements, and a more rigorous vetting process for couples seeking to reunite through marriage-based immigration. The state of marriage-based green cards before 2025. Prior to 2025, marriage-based green card applicants typically faced a processing time of about 10 to 12 months. The Biden administration introduced some flexibility, such as the option for low-risk applicants to skip the in-person interview and more lenient financial requirements for sponsors. However, with a shift in leadership and the likely return of Trump-era policies, changes are expected to significantly impact both the wait times and the documentation needed to qualify. Key changes in 2025: longer wait times and stricter requirements. Processing delays. One of the most noticeable changes in the marriage-based green card process in 2025 will be an increase in processing times. U.S.-based applicants can expect a wait of 14 to 16 months, while those applying from abroad may experience delays exceeding 2 years. This marks a significant slowdown from previous years when processing times were more predictable. Reinforcement of financial requirements. Stricter financial rules have been reinstated, including the return of the public charge rule. Under this rule, sponsors must demonstrate a higher income threshold to prove they can financially support their spouse without relying on public assistance. This policy is designed to ensure that the immigrant will not become a financial burden on the U.S. government. Applicants will need to submit more comprehensive financial documentation, which can include proof of income, tax returns, and bank statements. Mandatory in-person interviews. Under the previous administration, some applicants were eligible for interview waivers, especially if they had a low-risk profile. However, with the new policies in place for 2025, in-person interviews will now be mandatory for all applicants. This means that couples will have to prepare for face-to-face meetings with U.S. citizenship and immigration services officers, who will rigorously assess the legitimacy of their marriage. This additional step adds pressure on couples to provide convincing evidence of a bona fide marriage. Increased scrutiny and requests for evidence. As part of the heightened scrutiny under the 2025 policies, USCIS is expected to issue more requests for evidence. This means applicants will need to provide additional documents to prove their financial stability, relationship history, and other eligibility criteria. If an applicant's submission lacks critical information or clear evidence, the application could be delayed or denied. Higher denial rates for incomplete applications. With a more stringent vetting process and increased documentation requirements, applicants may face a higher likelihood of denial if they fail to meet all the eligibility requirements or submit insufficient supporting evidence. This will undoubtedly result in longer separation times for many couples as they wait for their cases to be processed and reviewed. Impact on different visa categories. Marriage-based green card applicants fall into several categories, and each faces different challenges under the updated rules. For example, IR1 and CR1 visas. The IR1 and CR1 visas are designed for spouses of U.S. citizens. These applicants are facing heightened background checks and increased vetting, which could lead to longer processing times and additional requests for evidence. F2A category. The F2A category, which includes spouses and children of green card holders, is experiencing slowdowns due to rising backlogs. In addition, the stricter financial requirements have made it harder for sponsors to meet eligibility standards, further complicating the process. Navigating the new process. what you need to do. Despite these new challenges, applicants who are well prepared can still navigate the process successfully. Here's a step-by-step guide to ensure you meet the requirements. Start with Form I-130. The first step is to submit Form I-130, Petition for Alien Relative, to establish the marriage relationship. This step can take approximately 12 months to process, and once USCIS acknowledges a petition, applicants will proceed to the next stage. Complete Form I-485 or consular processing. If you are applying for adjustment of status within the U.S., you will need to file Form I-485. Applicants outside the U.S. will need to go through consular processing and submit the necessary documentation to the U.S. Embassy or consulate. Attend biometrics appointment. Once your petition is processed, you will receive a biometrics appointment. During this appointment, USCIS will take your fingerprints, photograph, and signature for background checks. Prepare for the in-person interview. Given the mandatory in-person interviews for all applicants in 2025, it's essential to prepare thoroughly. Be ready to answer detailed questions about your relationship, daily life together, and plans for the future. Provide clear documentation such as joint financial records, photographs, and affidavits from friends and family attesting to the genuineness of your marriage. Meet financial eligibility. One of the most critical areas to focus on is meeting the financial requirements. Sponsors must now provide detailed financial documentation, including tax returns, proof of employment, and income verification, to demonstrate they can support their spouse without relying on government assistance. Married a U.S. citizen or green card holder. Immigration officers now ask who woke up first, your favorite side of the bed. Spouses of U.S. citizens or green card holders can no longer expect a smooth path to a green card through marriage. Immigration interviews are getting stricter under the Trump administration, with officers exercising greater discretion and increasing demands for documentary proof. This change stems from tightened policies introduced during the Trump administration to curb suspected marriage fraud and appears to have carried over. Immigration attorneys report a rise in detailed questioning and document requests, especially during consular interviews for spouses residing outside the U.S. For those applying for adjustment of status within the U.S., interviews by U.S. Citizenship and Immigration Services are also being conducted with greater scrutiny. Officers will be looking deeper, leaning into their discretion more often than they did in the Biden years. They're already spending more time verifying marriages, and we are seeing an increase in requests for evidence. Ashvin Sharma, immigration attorney, told TOI's Lubna Kabli. Experts say the increase in evidence requests could soon be formalized into policy. According to Sharma, consular officials are paying special attention to how the couple met, their intention to live together, and how they have maintained the relationship. Since the U.S. citizen spouse is not allowed to attend a visa interview in consular cases, the entire burden of proof lies on documents. Documents have to tell the full story. How the relationship began, genuine intent to live a married life together, how it's been sustained, and why it is bona fide. That means clear evidence of communication, visits, shared plans, and/or family involvement, said Sharma. Snell Buttra, managing attorney at MPZ Law Group, advises applicants to prepare with extensive documentation, including money transfer receipts, call logs, photos, joint accounts, and even life insurance policies naming the spouse. Additionally, be prepared to answer questions about your marital relationship, including your spouse's current employment, salary, education, and any prior marriages, she added. Long wait, higher suspicion for green card spouses. For those married to green card holders, the wait is longer and the scrutiny more intense. A typical 3 to 4 year wait can lead to tougher interviews and questions around the genuineness of the marriage during such long separation. The longer the wait, the more documentation you'll need: pictures, financial records, continuous communication to convincingly show that your marriage isn't just alive, but thriving despite the distance, said Sharma. He also warned of the power consular officers have, especially in posts like Mumbai, to issue 221G refusals or refer petitions for fraud investigation. Under the current administration, we can expect this discretionary power to be used more liberally and aggressively. Absence may make a heart grow fonder, but for immigration officers, prolonged absence makes suspicion grow stronger, Sharma said. Stokes Interview for domestic applicants. If the spouse is already in the U.S., The couple must attend an in-person interview with USCIS. In suspicious cases, the couple may be called in for a Stokes interview, where they are questioned separately and their answers are compared. Questions may include: 1. Which side of the bed do you sleep on? 2. Who woke up first today? 3. How many windows are in your bathroom? 4. Does your spouse have any food allergies? 5. How many locks are there on the front door? Although attorneys have not reported a surge in Stokes interviews, they advise attending such interviews with legal counsel. Well prepared, legitimate cases appear to be still holding up well under scrutiny. But it's also true that even genuine couples with weak documentation are going to feel the pressure. Sharma said, if a green card is denied due to an alleged marriage fraud, the spouse can be placed in removal proceedings, deportation. Buttra added, navigating the 2025 marriage-based green card process will require thorough preparation and an understanding of the new, stricter requirements. By staying informed and gathering the necessary documentation, applicants can successfully manage the challenges ahead and ensure the legitimacy of their marriage is clearly demonstrated. That is all today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
New immigration rules for green card sponsorship of families and marriage to a US citizen or a green card holder. In 2025, significant changes are expected in the US marriage-based green card process, driven by the potential return of Donald Trump to office, which may usher in a stricter immigration policies akin to those during his first term. This video is anticipated to result in a longer wait times, heightened financial requirements, and a more regular screening process for couples seeking reunification through marriage-based immigration. Before 2025, applicants for marriage-based green cards face processing times of around 10 to 12 months. Under the Biden administration, some flexibility was introduced, such as interview waivers for low-risk applicants and more lenient financial requirements for sponsors. However, the likely return of Trump's era policies will result in processing delays, with US-based applicants waiting 40 to 16 months and those applying from abroad experiencing delays of over 2 years. Financial requirements will also become stricter, including the restatement of the public charge rule, which mandates sponsors to demonstrate a higher income to prove they can support their spouse without a government assistance. One of the most notable changes will be the restatement of mandatory in-person interviews for all applicants, removing the option for interview waivers. This means couples will need to prepare truly to provide convincing evidence of a bona fide marriage, including joint financial records, photographs, and affidavit. Additionally, USCIS is expected to issue more requests for evidence, requiring applicants to submit detailed documentation to prove their financial stability, relationship history, and other eligibility criteria. Visa categories such as IR1, CR1, and F2A will face slower processing times and increased scrutiny, particularly due to rising backlogs. In response to these changes, applicants should start by submitting Form I-130 followed by Form I-485 or a consular processing and attending a biometrics appointment. Given the new mandatory in-person interviews, applicants must prepare for detailed questioning and provide extensive documentation to demonstrate the legitimacy of their marriage. Experts advise applicants to gather comprehensive evidence of their relationship, including communication logs, photographs, and financial records, to mitigate the heightened scrutiny and avoid delays or denials.